trusted guide in the world of U.S. immigration. We provide clear immigration news and insights and connect you with experienced attorneys who can answer your questions and guide you through the process. From visas to green cards, asylum to citizenship, we help you find the right legal expertise so you can move forward with confidence. ImmigrationQuestion.com. Real news, real answers, real quick. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by ImmigrationQuestion.com, your trusted source for immigration news, expert legal insights, and real-time conversations with licensed immigration attorneys. My name is Max Castra, and I'll be your host for today's important session, Proving Extraordinary Ability, Building a Strong EB-1A Case. The EB-1A Extraordinary Ability Visa is one of the fastest routes to get a U.S. green card. However, it's also one of the most challenging as applicants are required to demonstrate they've reached the very top of their field. Whether you're an attorney representing clients or a professional planning to apply, today's conversation will give you the tools to understand better how to build and present a compelling EB-1A case. That's why we're here to break down the standards, highlight strategies, and provide clarity on what it truly takes to prove extraordinary ability. We're honored to be joined today by attorney Sonu Lal, managing attorney of Gehi & Associates Texas office, with over 15 years of experience in business immigration and removal defense. Attorney Sonu Lal has guided numerous professionals, entrepreneurs, and families through the complexities of U.S. immigration law. He's a well-respected educator, regularly hosting live the Q&A sessions across multiple platforms and publishing insights for immigrants navigating policy changes. Attorney Sonu Lal, we are delighted to have you us today. Welcome.
Thank you for having me.
Of course. Before we begin, just a quick reminder, ImmigrationQuestion.com is a platform that connects users with licensed immigration attorneys. We are not a law firm, and we are not affiliated with AILA or USCIS. All legal services are provided independently by attorneys in our network. Let's dive right in. Attorney Lal, can you begin by breaking down what EB-1A Extraordinary Ability Visa is and how it differs from other employment-based green card categories?
Great question, first of all. So EB-1A is employment-based green card category within immigration law. How it works and how it's different from other categories. Number one, and most relevant, you can self-sponsor, unlike other employment-based green card categories where you would need sponsorship from an employer. So that's a most important part. Second relevant factor for this is, unlike other EB-2 and EB-3, which are backlogged for most of the countries such as India and China, and rest of the world, EB-2 and EB-3 are still backlogged, meaning you cannot immediately file your green card application, even if your immigrant petition gets approved. EB-1A is current for most of the world except for India and China. That's another beautiful part of EB-1A. Now, what is EB-1A? What do you have to show to US immigration? You have to show that you have extraordinary ability in your field, such as science, education, business, or arts. How do you show that? You have to show to immigration that you are among the top 1% in your field, whatever that you do. You may be in STEM field, you may be an artist, you may be in education, you may be a great businessman. Now, there are two ways to prove this, your extraordinary ability. Number one, if you have received one major award. For example, if you are working in STEM field, you win a Nobel Prize, slam dunk, you can get your EB-1A. Or for example, you're working in film industry, you win an Oscar Prize, that's a slam dunk again, you can get your EB-1A through that. But not everybody are going to get those kind of major awards. So the law provides alternative criteria, which says that if you can fulfill at least 3 out of those 10 factors, you may be eligible for EB-1A. I'll briefly discuss what those factors are and how you can build your profile towards those factors. Number one, if you have received any kind of lesser known international or national awards in your field. So keep in mind the award should be in your own field. For example, a few days ago, I had a consultation with a prospective client. He works in a medicine field right now. A couple of years ago, he received an award, but the award was totally unrelated, but he was filing his EB-1A form. So he probably cannot use that award towards his EB-1A, meaning your award should be relevant to what your field you are in. It's important to know. Another factor is that we commonly argue when we file our EB-1A cases, membership in a distinguished organization. I get this question a lot when I do initial consultation with people. What does it mean to be a member of distinguished organization? It means that your membership in that association cannot be a fee-based. For example, if I'm an attorney, I'm a member of New York Bar. If I were to file my EB-1A, I cannot just say that I'm a member of this distinguished organization, so I should be accepted for EB-1A. It doesn't work that way. The qualification is to become a member of that organization. The criteria should require something extraordinary in you or some kind of expertise in you. If that's a criteria to be accepted in that association, then you can argue that factor that you qualify for that factor. Another factor is if you have judged any kind of competitions in your field. So if you're judging any kind of competitions, events, which actually shows that you are already an expert in that field. So if you have become a judge, or maybe you have reviewed some scholarly article, then you can argue this factor easily. Next one is if you have performed any critical role in a distinguished organization. So maybe you are working at Google as a software engineer and you're leading a team, their AI team, meaning you are performing definitely a critical role, and Google is a distinguished organization. So you can fulfill such a criteria. Another factor is, have you written any scholarly article which got published in some business or some renowned journals? It's very, very important that they get published in some well-known journals. If you have, even if you have one article, you can still argue for that factor. Another criteria is, have you been published in some major media? Which means if either you or something about your work got published in some kind of a major media, such as Bloomberg, New York Times, etc., and again, you can qualify for at least under this factor. Another most common factor that we use a lot in our EB-1A petitions, are you being paid substantially higher than your peers? For example, if you are filing as a software engineer, you're filing for EB-1A, and you're working in New York City, where the average salary probably for a software engineer is somewhere around 150 or 200K, but you are getting $400,000 a year, then you can provide those proofs that you're getting that much salary, which is an indicator that you have an extraordinary ability and you are quite an expert in your own field. So these are the common criteria that we routinely argue in our EB-1A petition. If you are considering EB-1A, you can consider all these factors. And with that, we can take questions.
Thank you very much, Attorney Lal. And meeting the extraordinary ability standard can feel overwhelming. In your experience, what are the most essential criteria USCIS looks at when evaluating these cases?
I'll give you very a pro tip that I've seen in my practice. Two things about it. Number one, the easiest criteria to meet is the judging factor. For judging, all you have to show that you have been a judge of this some kind of prestigious competition. All you have to provide is a letter or a proof or a certificate that you are the judge at that competition. And USCIS will easily accept that. The hardest factor that I get a lot of pushback from USCIS in terms of RFEs is a membership factor. For example, I file a lot of EB-1As for IT professionals. A lot of these engineers, they are member of what is called IEEE. And if you're a regular member at IEEE, USCIS will reject this criteria. In most cases, if you are at least a senior member or a fellow at IEEE, then you are likely to be accepted. Even in some cases, I still get a pushback, even if you are a senior member. So that's about how USCIS takes these factors.
Thank you for the pro tip, attorney. When evidence is often the backbone of a petition, could you share practical examples of the types of evidence USCIS values most in an EB-1A application?
It's a great question. The most relevant part of any EB-1A are recommendation letters. But what matters is the substance of those recommendation letters and who they are coming from, meaning the signatory or the writer of those letters should also be an expert in that field. That's number one. Number two, how that person knows you or at least knows your work. There should be a complete background in the recommendation letter, how that person come to know you. Maybe your supervisor, maybe your ex-colleague, and how that person knows that you have extraordinary ability in your field. Very commonly, if that person has already worked with you in a supervisory capacity, or maybe he was a colleague, that's how that person knows you or your work. So all those facts should be in that recommendation letter, meaning that those recommendation letters kind of a backbone for your EB-1A petitions.
Thank you, Attorney Lal. And many applicants struggle to understand the difference between ordinary success and extraordinary recognition. How do you help clients frame their achievements in a way that meets EB-1A standards?
Well, absolutely, absolutely. Many people don't understand this difference. My normal advice to them is when you are presenting your EB-1A case, what you are doing is you are telling your own story of success to USCIS. What matters? Presentation matter. How you present, how you are narrating your own story. Highlight the most relevant achievements of your career in your case and support them with a documentary proof. Meaning, let's say you have some lesser known awards that you have received. You probably may not have received some major awards. You can still argue that award factor if you can highlight why that award is relevant in your own field. That award may not be known generally or across common people, but that award may be known in your own field. So you can highlight those factors that's how, even though the award is not well known, it's relevant in my own field. That's why it's relevant for EB-1A. That's how you present your case.
Of course. Thank you, attorney. And for attorneys supporting clients across diverse fields, such as science, business, or the arts, Attorney Lal, what are the strategies do you recommend to ensure petitions are strong and tailored?
Yeah, great question. So in addition to that, I get a lot of calls from other of my colleagues or attorneys who may not be well versed about EB-1A process. If any attorneys are listening, and if you do not have much experience in filing business immigration in general or EB-1A in particular, please do not hesitate to take help from colleagues who are expert in this area of law. That's number one. And to answer your question, as I said, all you have to do is narrate your story, highlighting the achievements of your career and why those achievements are relevant in your field. Some of the achievements, for example, may not be as visible to common people, but in your own field, they are probably very, very relevant. That this question comes a lot in terms of the salary factor when we are arguing. In certain categories, the salaries in general are usually higher. For example, if you are working as at a senior level in IT field, maybe a VP or a senior engineer, the general salary in that for that position anywhere is higher already, maybe $200,000, $300,000. And if your salary is also $200,000, $300,000, if you look at it in general, $200,000, $300,000 is a very good salary. But for EB-1A purposes and for that particular role, you cannot fulfill that factor because that's a general salary for that position. You have to show somewhere higher than that salary. So these are the nuances that people need to understand when they are submitting their EB-1A cases.
Thank you very much, Attorney. Just a quick break to everyone tuning in on Facebook, YouTube, LinkedIn, and beyond. Thank you for joining us today. Whether you're an attorney, a student, or a professional seeking clarity on EB-1A, we're glad to have you with us. If this is your first time, welcome. Immigration Question is a trusted meeting place where immigrants and attorneys connect. You can ask immigration questions for free in any language and get matched with a licensed attorney for guidance. Many of you may also qualify for a free confidential consultation. We're also proud to share that Immigration Question is now a BBB-credited business, reflecting our commitment to honesty, transparency, and serving immigrant communities with integrity. Attorney Lal, with your years of experience, what are your thoughts on how platforms like Immigration Question are helping immigrants and attorneys connect more effectively, especially in a complex area like EB-1A petition?
I think it's a great platform. It connects not only the people who are looking for immigration advice related to family matters, etc. Connects both the attorneys and people who are looking specialized kind of immigration services. So it's a great platform in my view.
Thank you very much for your perspective, Attorney Lal. Before we move on to our live Q&A session, let me ask one final question. What are the most common pitfalls or mistakes that you see in EB-1A filings, and how can applicants and their attorneys best avoid them?
Very commonly that I see the paid awards. There are certain companies which offers awards if you pay them a certain kind of fees. And if you are trying to do that, you're paying and you're getting that award, I don't think that's going to work for your EB-1A petition because USCIS knows all of those kind of things. So avoid doing that. Keep your EB-1A petition as organic, as original as possible.
Beautifully said, Attorney. If you're joining us, we've been having an insightful conversation with Attorney Sonu Lal on the topic Proving Extraordinary Ability, Building a Strong EB-1A Case. We're now moving into our live Q&A segment. This is your chance to ask questions directly. Drop them in the chat or call us live at 516-703-3483. That's 516-703-3483, and we'll get to as many as possible. Right, we have our first question from Afar. Do I need a big award like the Nobel Prize to qualify for EB-1A visa?
So as I mentioned before, there are two ways to get EB-1A. Either you receive a major award, such as a Nobel Prize. In that case, that's the only thing that you have to do. You got a Nobel Prize, I would submit the petition along with a copy of that award. You will get the EB-1A. But vast majority of the people, they are not getting these kind of awards. So the alternative, as I mentioned before, 3 out of 10 factors. So even if you have received some lesser known national or international award, that can work. All you have to do is you should be able to show to USCIS that you fulfill at least 3 of those 10 factors. So only winning a major award such as Nobel Prize is not the only way to get your EB-1A.
Got it. Thank you, Attorney. Let's try to wait for more questions. We have one from Benson. If I don't have a job offer in America, can I still file for EB-1A?
That's an excellent question. As I said, what differentiates EB-1A from EB-2 and EB-3 is self-sponsorship. Meaning for EB-2 and EB-3, you would need an employer, except national interest waiver, you would need an employer to sponsor your green card application. But with EB-1A, you do not need any sponsorship. You can self-sponsor yourself. You do not need a job offer in America. That's a great part of EB-1A.
Right, we got one from Gunther. Please, is recommendation letter enough to win EB-1A?
I get this question a lot when I do my consults for EB-1A. How many recommendation letters are sufficient? So there is no magic number. I cannot give you a fixed number. All I can tell you in practice, what I have used in my filing. In my filings, I have used somewhere between as little as 6 recommendation letters to as much as 15 recommendation letters. So that's a range I have used. But again, there is no magic number. What matters is the content of the recommendation letter and who is the author of those recommendation letters. That's what matters.
So quality over quantity still. Thank you, attorney. Okay, we have one from OSIS. I am an entrepreneur with my own business. Can I apply for EB-1A?
So EB-1A typically is in the field of science, arts, education, and business. So if you are a businessman, if you can show your extraordinary ability in your own business, yes, you can apply for your EB-1A.
Right, and we have one from Mirabel. Can I apply for EB-1A while I'm still on my H-1B visa?
Majority of the cases that I file for people who are already in the US, and typically they are either on H-1B visa or L-1 visa. So to answer your question, yes, while you are on your H-1B, you can file your EB-1A.
All right, we have room for one more question. Let's try to see what it is. We have one from Isaac. If I have national awards from my country, can USCIS accept it for EB-1A visa?
So with respect to the awards, and if you are targeting 3 out of 10 factors, then even if you have a national award in your own country, you can still argue that awards factor. All you have to do is explain to USCIS why that award is relevant for your case and what is the significance of receiving that award. This is what all you have to do. If you can do that, you can at least fulfill one factor out of those 10, and then you have to focus on rest too. That's how I would file your case.
Thank you so much, Attorney Lal, for sharing your expertise today. Your insights into building strong EB-1A petitions are truly invaluable. And to our audience, thank you for being here. We hope today's discussion gave you clarity and practical strategies, whether you're preparing your own petition or advising clients. Remember, you can always visit www.immigrationquestion.com to ask your immigration questions for free and connect with a licensed attorney. Many of you may also qualify for a free confidential consultation. If you'd like to revisit today's session or share it with others, the full replay will be available soon on Spotify. Just search Borderless Talk by immigrationquestion.com. Join us again next week for another timely and vital conversation you won't want to miss. Once again, thank you, Attorney Sonu Lal, and thank you to everyone watching. Until next time, stay informed, stay prepared, and stay encouraged.
It was a pleasure.
Lovely
Thanks
rest.
for having me.
Thank you, Attorney. See you again soon.